Hey everyone, and let's jump right into this explainer. Today, we're building a masterclass understanding of how the Indian judicial system actually protects our democracy. Whether you're studying civics, you're a legal nerd like some of us, or you just want to understand the daily news headlines a little better, this session is going to give you a crystal clear, structured view of how the courts really work. We're going to completely decode the foundations, the structure, and the incredible powers of the judiciary.
But first, before we map out the physical architecture of the courts, let's test a really common misconception about who actually holds the power at the highest levels of justice. A lot of people just assume that because the executive branch, specifically the president, appoints the judges, they can also easily remove them. Can they just fire a judge at will if they disagree with a ruling? Keep that question in the back of your mind, because the answer reveals the absolute genius of the Constitution's design.
To truly grasp these concepts, we're going to build our knowledge step by step through 5 crucial sections. First, the foundational rule of law. Second, the integrated judicial pyramid. Third, the independence shield. Fourth, court jurisdictions. And finally, pills and judicial activism.
Let's start with Section 1, Foundation, Rule of Law. Because honestly, you can't understand the structure until you understand the ultimate goal. The fundamental purpose of the courts isn't just about punishing criminals, right? It's an accountable organ designed to settle disputes in strict accordance with the Constitution. It's there to protect the rule of law. This literally means ensuring that no one, not even the government itself, is above the law. By guaranteeing the supremacy of law, the judiciary acts as the ultimate safeguard for your individual rights.
Now think of this next part as your ultimate cheat sheet. This is our important formula list, the essential constitutional articles you absolutely need to anchor the rest of this masterclass. You've got Articles 124 and 214, which establish the Supreme Court and the High Courts. Then Articles 32 and 226 are the crucial tools used to protect our fundamental rights. And finally, Article 143 allows the President to actually ask the Supreme Court for legal advice. Definitely lock these into your memory.
Okay, moving to Section 2, the integrated judicial pyramid. With those formulas locked in, let's see how this builds into the physical architecture of the courts.
This is actually a fascinating point where a lot of people get confused. Unlike some other federations out there, India doesn't have separate state Supreme Courts that get the final say on state laws. Nope. It's one massive, unified pyramid with the Supreme Court at the absolute apex. Beneath it are the high courts, and beneath them, the district and subordinate courts. This integration means that decisions made by higher courts are strictly binding on all the lower courts. It's a single, cohesive unit of justice.
And here's a super easy memory trick for you to remember this structure. The 1-2-4 start. Article 124 is the spark that formally establishes the Supreme Court's authority over the entire country. From that 1-2-4 start, the power just trickles down through the rest of the judicial hierarchy, ensuring the law is applied uniformly from New Delhi all the way down to a local village court.
Then there's this number, 34. That represents the total sanction strength of the Supreme Court today. That includes the Chief Justice of India and 33 other judges who literally carry the weight of this massive pyramid on their shoulders. Just put that into perspective for a second. 34 individuals are ultimately responsible for interpreting the Constitution for over 1 billion people, settling massive disputes between states, and finalizing life-or-death criminal appeals. It's wild.
Which brings us perfectly to Section 3. The independence shield. Because to enforce the rule of law fairly, those 34 judges need some serious protection.
Think about it. Without total independence from the executive and legislature, impartial justice is just impossible. So the Constitution insulates judges structurally and financially. Their salaries aren't constantly up for debate by politicians. They get a fixed tenure until age 65, so they don't have to stress about losing their jobs if they rule against the government. Plus, they have complete immunity from unfair personal criticism and can penalize people for contempt of court. It creates this vital, protective bubble.
So back to our earlier myth-busting question. Can the president fire a judge at will? Absolutely not. Removing a judge requires this incredibly rigorous parliamentary impeachment formula. A judge can only be removed for proven misbehavior or incapacity. And just look at these numbers. It requires a majority of the total strength of each house and a 2/3 majority of those present and voting.
The framers of the Constitution made this process brutally difficult on purpose, so judges could do their jobs without fear or favor. And you know what? The shield works. History proves it. Even when motions were brought up like against Justice V. Ramaswamy in 1991 or Justice Sumitra Sen in 2011, those strict voting thresholds meant that, to this day, No Supreme Court judge has ever been successfully impeached and removed in India.
All right, Section 4, demystifying court jurisdictions. Now we know who the judges are, let's untangle exactly what types of cases they're actually allowed to hear.
See, a court can't just pick and choose any case on a whim. The central power of the Supreme Court branches into 4 specific lanes: original, appellate, advisory, and writ. Operating within these defined scopes of power is called their jurisdiction. Understanding these 4 distinct branches is totally crucial to understanding how a case actually makes its way to the highest court in the land.
Now, people mix these two up all the time, but the key takeaway here is simple. Original means the Supreme Court is the very first stop, while appellate means it's reviewing a lower court's homework. So if the central government has a huge dispute with a state government, that doesn't start in some local district court, it goes straight to the Supreme Court under original jurisdiction. But if you're appealing a major sentence handed down by a high court, that falls under appellate jurisdiction.
Here is a genuinely surprising distinction. Both of these articles deal with issuing specialized legal orders called writs, like habeas corpus to prevent illegal detention. But the High Court actually has a slightly broader scope for issuing them. Under Article 32, the Supreme Court can only issue writs to protect fundamental rights. But under Article 226, high courts can issue them for fundamental rights and for other purposes, giving them a wider territorial net for providing immediate legal relief. And these rules lead to massive historical shifts through something called judicial review. This is the court's immense power to literally strike down laws that violate the Constitution's core framework. Take the 1973 Keshavananda Bharati case. The Supreme Court declared Parliament cannot alter the basic structure of the Constitution. Later, in the S.R. Bommai case, they established that federalism is a part of that very basic structure. Judicial review is basically the ultimate emergency brake on legislative overreach.
And that leads us to our final part, Section 5, PILs and judicial activism. We're shifting focus from the judges at the top to how everyday citizens access this massive system. Historically, if your rights weren't directly violated, you couldn't approach the court, period. But PILs, public interest litigation, completely flipped the script. It was a revolutionary shift that democratized access to justice. It meant that if a marginalized group couldn't access the courts themselves, a social worker, a lawyer, or just a concerned citizen could step up and file a petition on their behalf. A real game changer. If we trace this back to the late 70s, we see the courts getting really proactive, a concept known as judicial activism. For instance, the famous 1979 Hussein Ara Khatun case wasn't initiated by the victims themselves, but on their behalf. And that single case led to the release of thousands of under-trial prisoners who had literally spent more time waiting in jail for a trial than their actual maximum sentences would have been.
Now, like anything powerful, judicial activism is a double-edged sword. On one hand, it's absolutely democratized the courts, cleaned up the environment, and made elections fairer. But the flip side? Frivolous PILs have seriously overburdened an already stressed judicial system, and critics rightfully point out that it sometimes blows the necessary separation of powers, seeing the judiciary step into the administrative territory of the government. So, I want to leave you with this final thought to ponder as you reflect on the delicate vital balance of power within the Indian judicial system. If the courts step in and do the work of the executive for the sake of the public, does that ultimately strengthen our democracy, or does it undermine the whole constitutional structure? It's a very fine line between protecting the weak and overstepping boundaries. Understanding that tension, that is the real masterclass. Thanks for joining me on this explainer. Keep asking questions and keep exploring how our systems work.